as I said, the subject matter of this law are all the 102 crore individuals. Now we are trying to talk something which is high-tech, let us say Bangalore-centric talk. Why don't we talk something about Hassan or something about Gulbarga or someone called Boragoda in some remote village of Mandya? Will he be capable to do that is something which we have to see.
So again, because it's a too technical issue.
Correct. As I said,
prosecution to go beyond reasonable doubt. That's the main problem.
See, law, every agency has its shortcomings. But it is better that we give this responsibility from an individual level to the agency level who have the competency to do it.
One small idea about property, what he has raised is a very valid question. Could you consider it as an asset rather than a property?
Yeah, we can.
Now we have been talking about it for a long time. We should consider this as an asset. Asset is completely different from the concept of property. Therefore, I think you should be looking at in future information as an asset. And there is a concept of insurance, there is a concept of liability, damages, all those related to that. I think it should be rather, better to consider an asset rather than a property.
And here when we say damages, to define what is damage, we need to have a parameter.
Yeah, that's right.
For that, we have to say asset,
property may not be the right position we can take on the information. This is basically an asset. And I think most of the European countries have already thinking in terms of ensuring this information asset.
Yeah, the very purpose of this debate is to raise questions, so it is nice that all these debates are coming up here.
Thank you. You want to ask one?
It was a very good critical analysis, but what I was thinking is, as this Data Protection Act is in requirement of a global scenario, so was an attempt being made, to compare this present act in its present form with other acts of say specific countries or some global standards where we can draw, okay, these are the points where we are lacking behind, so that if we give a suggestion for amendment or incorporation of changes, it will be fruitful. Rather than just thinking from Indian perspective, an attempt should have been made to compare the existing standards or legislations in the respective countries and an analogy drawn, so that we would have benchmarked ourselves against international standards.
Yeah, firstly, this is not an act, this is just a bill which is present and it is not being made, and it is just a bill which has 14 sections. And the very objective behind this bill was to see that various organizations who collect this information, like let us say you take a air flight and some Airtel, some people buy the information from your Deccan Airways and they call you. Those things do not happen. That was a very limited objective of this act, but we have tried to enlarge it to extend to various other areas. And here one thing we have to keep in mind is the definition of a citizen is not being made. See, if we try to say this applies to India, for the purposes of enforcement, we can say this can geographically be in India. But information, private information may include any information collected. So there is no very limitation made on whose information, whether it is Indian citizens' information or the information which is coming from the entire world.
The second one.
Yeah, since it is not being made, so any private information which includes everybody.
Thank you. Now, the third subject of Mr. Prasanna's security issues, combating terrorism through cyberspace. You have a question?
Well, I have no words to thank Mr. Prasanna for having highlighted us. But my apprehension is, so many cases have been filed, bomb blasts are happening, but how far our system, judicial system, police system, prosecution system are being equipped with the required information to plead on behalf of the state and to see that the convict or the accused will be convicted with heavy penalty. And I request the chairman of this session to take this matter and to pass the necessary resolution in the end, because in the end of the national seminar we have to pass the resolution to put it as a top priority matter for the government to implement this. The judiciary has to be trained, the prosecution machinery has to be trained, and above all, the police personnel have to be trained. Therefore, I feel this is a very, very important area in which the seminar has to apply its mind and pass the necessary resolution. What do you say, sir?
Yeah, I don't know if I am the right person to talk on this topic. So, see, if you look at my portfolio for last 6, 7 years or 8 years, is I have been developing technologies for security agencies and law enforcement agencies. So we have also effectively sometimes deployed it. We have been able to, collect information, neutralize modules and things like that. But unfortunately, when it comes to law and prosecution, I am not an expert on the subject. So I don't know. So why I took this seminar was, I wanted people to understand that this is how it will work. If you really want preemption, you really want, to control terrorism, you really want to curb these bad people from killing good people, so this is what we have to do. But how it is to be done by law, I don't know. So that's my answer. Yeah.
Just a few points that I noted during your presentation. One, you were praising the carnivore system. I'm put in a difficult position because I wasn't sure whether you were just presenting information or whether you were actually supporting the information which you presented. So, assuming you were praising the carnivore system, well, it was actually found to be unconstitutional. Like ACLU and EFF launched a case against that, and the courts held it to be unconstitutional. Secondly, you were talking about SSL and PGP and the possibility of and in PGP you specifically leveled the problem of 40 bits versus and SSL you said there's a possibility of other governments snooping. Okay.
No, not in SSL.
Yeah. Okay.
I only mentioned SSL being used by terrorist element for their own covert channel communication.
No, and you also talked about it being closed. Now, what I wanted to say was there are implementations of SSL such as OpenSSL, which are open source, and SSL itself is an open standard. Okay, so there's no possibility of other governments injecting a backdoor into such a. And secondly, about PGP, there is, as you would know, Phil Zimmerman, the guy who created PGP. He quit the company in 1992. Okay, and went to, because the government was trying to get him to create a backdoor. What he created instead was he made it open source. Okay, and that led to Open PGP and another thing called PGPI, okay, which basically means that the government cannot include such a thing. Now, what you were saying was what was sought to be done in 1992. After that, PGP has been open, and at that point of time, okay, PGP was not allowed to be exported out of America, even though the people who were contributing to the research were coming from Europe also, but it was American technology. Now it is. Now, export regulations in the US, they dropped it in security matters. So, my point is, so that kind of, the apprehensions that you have aren't warranted.
Yep.
And
I'll answer your first question, so that people don't get confused. So, see, as far as SSL interception is concerned, there is an open tool which is available called Kane-Enable. Just type Kane-Enable, you will get it. Okay, so ISPs can deploy this with a situation called man-in-the-middle attack, where any communication flowing on SSL can be intercepted. See, basically what I do is I reverse engineer tools, and I study the tools, and I develop technologies for security agencies. So this is what I do. So when I talk about PGP, these are not apprehensions, but these are based on valid reverse engineering which we have done, and we have come to certain conclusions. Now, can I share it with you? No. Because simple thing is, because the legal agreement of PGP or any software which says clearly that it cannot be reverse engineered. So I don't know the legal aspects of all these things.
It's open source, anyone can see.
See, as far as open source is concerned, I'll give you a simple, I would say ignorance of people, okay. See, what happens is most of us, when we go to an open source tool, now we don't understand the source codes. We don't understand the programming language. So what we do is most of us download the source code because we want to be sure that the source code is published. There will be a exe file or a binary file which is compiled and which is kept. No, I am talking about the general public. Okay, so what happens? We always download the binaries and we start using the binaries. Now what we don't know is the source code will be the original source code, the binaries will be bugged. See, in real life situation, this is how it works. This is how they do it. So there is nothing called apprehensions or I have known sites where they will take an original file they will add one more file along with it, and then they will put it on the website. So this is how it works. I think, we totally come from two different spectrums of thinking. So whatever I say, finally you are not going to be convinced. So let us not waste everybody's time on this. Thank you.
So I take it that completes the list of questions. Anybody else? Okay, thank you. It was a very, very interesting session. Well, to sum up all the three together is not an easy job, but basically I wanted to make one or two points relevant to what has been discussed today. You see, the Information Technology Act is being amended. The bill is pending approval by Parliament, discussion and approval by Parliament. So at this stage, this is the time when we can give a free rein to our thinking, and in the light of intellectual discussions that have taken place, suggest through Mr. Navi proposals for amendments, which will be taken into account by the Department of Information and Communications Technology. And that's the time, this is the time for that, because once the bill comes into an act, becomes an act, it will be too late to do that at that stage. In this context, I just wanted to say that there are certain criteria that we tend to look for in not only formulating a law, but in amending the law. And I'll just like to mention those 3 or 4 which you can keep in mind before you make this suggestion. One, are the current provisions of the Information Technology Act and the Amendment Bill and the other Personal Data Protection Bill, are they clear, consistent and predictable? 2, do these conform to internationally accepted principles and practices? That is where the provisions of law enacted in other countries or international conventions and guidelines become relevant. I would like to go into details, but probably this is not the time to do that. Third, are the provisions over stringent? Because someone said that it's too draconian in some cases, or are they, and if you do it excessive, if you do excessive regulation, then what happens is the economic transactions, electronic commerce, e-commerce becomes dampened and it doesn't grow. So that danger should be avoided. On the other hand, is the regulation less? Are the provisions leading to under-regulation? What happens is then, in that case, some of the instances which were pointed out, why does that happen? Because the regulation is inadequate. Partly because we are not aware of how to regulate, partly because we are not regulated. Are the rights and duties of the persons concerned defined in a just, reasonable and balanced manner? In fact, more than 3 times the suggestion was made that there should be a balance between the rights of the individual, the privacy rights of the individual, and the social good, the rights of the society, and the security interests of the state. So are these provisions balanced, just, and do they provide a just apportionment of rights and duties between this individual and the society and the state? Finally, are these enforceable, and are the redress procedures easily accessible by the parties? If law is not enforceable, there is no point in making a law or amending. So these are some of the considerations which I thought I should keep before you. In fact, before you consider this bill, that data protection bill, there are two purposes to be served by that. One is what is mentioned in the objects and reasons of the bill. I don't know how far we have seen the objects and reasons of the bill. Basically, it is to make sure that whatever information is collected by one organization from an individual is not passed on by that organization to any other organization without the consent of the individual. And the information should not be passed on to a third party without the consent of the individual. So the question arises, what are the parameters that we should look for in the bill? Number one, what kind of information can be collected? Number two, how is the information to be collected? Number three, can the information be collected and disclosed to a third party? If so, under what conditions? Obviously, it has to be with the consent of the person concerned, the individual concerned. And there are other, the other countries go into certain other aspects not found in the bill, which I noticed. For example, the European guide, there was a directive of 1995 by European Union, which is very strict, which says that the information collected by European citizens from European organizations or individuals, when they are processed, the process is a larger definition, I mean, that means collected, stored, even disclosed. The bill, of course, in one place it says the processing includes disclosing, but in another place it mentions processing and disclosing. I mean, there are certain drafting lapses which can always be corrected. These are not very important. See, when the European guidelines specify that this information should be protected not only inside Europe but outside Europe. That is, when the information is exported to India, for example, it should be as much protected as it is protected inside Europe. Now, this has put pressure on countries like us to pass privacy legislation. So, the privacy legislation has got two aspects. One is an individual's information should not be given away to a third party without that individual's consent. The other is, we have to pass this legislation in order to do business with Europe. Now, where does USA stand? Now, USA has got an arrangement with EEC, with European Union, called Safe Harbor Agreement. The Safe Harbor Agreement says, it's very strict. It says, it almost makes it impossible for India to deal with either USA or European Union because of the strict standards of privacy that is insisted upon. So the question arises whether our bill does it meet those standards or not. So it is from this angle also I would like you to examine. And for example, certain aspects are not covered by this bill. For example, an individual's right to access and to correct, amend or delete the information held about him or her is not provided for in the bill, as far as I see. Some countries insist on that. So do we go in for that? And some countries also insist that the information, the person who supplies the information must be accurate in supplying that information. It is not as if you are not a lawyer, but you say you are a lawyer. See, if you give an information, it should not be communicated to a third person without the consent of the person who gives the information. But should that information be accurate or not accurate? Some countries insist it should be accurate. But more importantly, this right to access the information about oneself, correct, amend or delete the information is also provided for. So should we incorporate that provision? These and other questions arise. I wanted to give a free thinking to these aspects, and I thank you very much for
going to be the chairman, and then and it was very interesting. So I want to thank on your behalf the 15 panelists. Thank you.